So next, let's move on to the process by which you would be able to avail yourself of this FMLA leave. And it's a pretty general standard. Typically, you're required to try and give 30 days notice to your employer, if that's foreseeable. If there's a situation where 30 days notice is not foreseeable, the standard is just you should give it as notice as soon as possible, or as soon as it's practical for you to do it. You may also be asked to give some documentation to your employer, including possibly a medical certification. There are certain forms that some employers like to use, and you can access them on the U.S. Department of Labor websites. One of the forms is a WH-380E, it's called. This form is actually, it includes a certification for your health care provider to fill out. So there's a portion for your employer to fill out, there's a portion for the medical certification, and then you would return that to the employer. And that it's not something that an employer has to use, but that's something that is available and many of them will use. And then once you submit that form, then your employer has an obligation to notify you as to whether or not you are eligible to take the leave. If you're not, to provide you with an explanation. There's another form also that you could access from the same website. It's called the WH-382, and it's the designation notice. Again, employers don't have to use it, but it's one that sometimes they will, and it will give you the details about the leave that you're going to be taking. The next aspect of FMLA leave is the benefits and protections that you have while you're on leave. And this is a fundamental part of the FMLA, is that it's providing you with job protection while you're out of work. And basically you're mandated, the employer's mandated to maintain your health coverage and your health benefits while you're on your leave as if you were still employed. And in addition to this, when you are ready to return to work, the employer has an obligation to return you to an equivalent position than the position you left. It doesn't have to be the exact same position, but it has to be a substantially similar position with equivalent pay, benefits, and other employment terms. So the only way that you could possibly not be returned to your position in a lawful manner would be if your position was eliminated for a reason that has nothing to do with the leave. For example, it would need to be if you're in a specific department and the entire department is laid off because of documented downturn in business, something of that nature. That may be a basis for you not to be returned to your position. These situations are very specific. A situation that would not be a lawful situation to an employee trying to return to work is, and this is one that we see that does happen, the employee takes the FMLA leave, and when they're ready to return to work, the employer during that period may have been covering that employee's tasks by having employees cover. Maybe they didn't need to hire someone temporarily while you were gone, and the employer's been getting by. It's been fine. They realize they just, they don't really need you. But unfortunately, for them, that is not something that's going to be considered to be lawful. They can't just decide that, we realized because you were on leave that we didn't need you anymore. So that's something that they wouldn't have realized, but for you going on leave, that's not going to be something that's going to be lawful. Yes?
Is there any period after that where now you're back at work and they say, oh, we don't need, is there a period when you go back to work, they say we don't need you and try to have you not come back, and now you're there for a month or 2 months, and now they say, you know what, your FMLA is done, or you can be fired? Or is there a certain period of time that you have to be still employed?
The FMLA specifically provides for protection during that 12-week period when you're out. However, there may be situations where there's other protections through the FMLA. You can't be retaliated against for taking FMLA leave. So if it's a situation where the employee feels that the termination is based on an unlawful reason, it has to do with taking the leave, certainly that may be a situation that could be that could be unlawful. Again, the 12 work weeks is the set period for the statute, but there are protections built into the FMLA that say you can't retaliate against an employee for any basis for taking that leave. So it's a case-by-case basis, obviously, but there may be protections there for the employee. Sure.